From the north of Hungary, we are moving now to the south, and we will listen to the presentation of Professor Srđan Šarkić, who will speak about medieval constitutional provisions, norms in the Serb kingdom. And from now on, we will have on-site presentations.
Ladies and gentlemen, Serbian medieval law had no documents such as Magna Carta of 1215 in England and Bulla Aurea of 1222 in Hungary, but some provisions from the codification of Stefan Dušan contain the ideas which even today would have belonged to a constitution. Those ideas penetrated in medieval Serbia under the strong influence of Byzantine law. The reception of Byzantine law in any Slavonic country culminated with the great work of Serbian legal tradition, codification of the Emperor Stefan Dušan. This was realized in 1346 when King Dušan proclaimed himself the true believing Tsar and autocrat of the Serbs and Greeks. You can see the territory of Serbian state during the reign of Stefan Dušan. Educated as a young man in Constantinople, Dušan knew very well that if his state pretended to become an empire, it should have, inter alia, its own independent legislation. Accordingly, he began preparation for his own law code immediately after the establishment of the empire. In a charter of 1346, in which he announced his legislative program, he said that the emperor's task was to make the laws that one should have. These laws are, without a doubt, of the type which Byzantine emperors had, namely, general legislation for the whole of the state's territory. In the social and political circumstances, the Serbian Tsar had to accept existing Byzantine law, though modified in accordance with Serbian custom. A completely independent codification of Serbian law without any Byzantine law could not be produced, and therefore the Serbian lawyers created a special Codex Tripartitus, codifying both Serbian and Byzantine law. In the old manuscripts, Dušan's law code is always accompanied by two compilations of Byzantine law translated into Old Serbian language. The abbreviated epitome syntagma katastichion, or alphabetical syntagma, nomocanonic miscellany put together in 24 titles. Each title has a sign of one of Greek alphabet letter, of Matthias Blastares, a monk from Thessalonica, and so-called Justinian's Law, a short compilation of 33 articles regulating agrarian relations. Dušan's law code, Dušan's law code in the narrow sense is the third and the most important part of the larger Serbo-Byzantine codification, and it was issued at state councils held in Skopje, actual capital of North Macedonia, on 21st May 1349, first 135 articles, and in Ceres, in Greek Macedonia, 5 years later, articles from 136 till 201. Dušan's law code did not survive in original text, but we dispose today with the 27 copies. The copy that you see on the slide was found in the city of Prizren, today in Kosovo, and it is either from the end of 14th or beginning of the 15th century. Opinions of scholars are divided. As the year of promulgation, here, you see, here, is 6,857, according to Byzantine style, ab orbe condito, meaning from the creation of the world. Byzantines believed that the world was created 1st September in the afternoon, 5,508. So, when you take 6,857 minus 5,508, I was very bad in mathematics, it makes 1349. It's the year of the promulgation of the code. And this is the first page of this manuscript called Prizrenski, from Prizren. So, can you read the text? No, if you cannot read, I will read it to you in English. So, the beginning means the law of the true believing Tsar Stefan in the year 6,857, the second of the Indiction, at the feast of the Ascension of our Lord on the 21st day of the month of May. This code is established by our Orthodox Council, by the Most Holy Patriarch Kyrio Anikios, and by all the archpriests and clergy, both small and great, and by me, true believing Tsar Stefan, and all the lords of my empire, both small and great. The fragments of Dušan's Codex Tripartituts, which from modern constitutional legal view are of the utmost validity, are, first, Chapter B5 of the Syntagma of Mateas Blastares, translated and accepted in Serbia, and was taken from epanagoge, Greek epanagogi, return to the point, more correctly isagoge, Greek isagogi to nomu, introduction to the law. Well, in my presentation, you can find first the original Greek text of Syntagma. After that, translation into all Slavonic language, and finally, English translation. English translation runs as follows. The emperor or Tsar is the lawful ruler, the common good of all subjects. He does not do good out of partiality, nor does he punish out of antipathy, but according to the virtues of the subjects, and like a judge at the trial, gives the awards equally, and does not give the benefit to anyone to the detriment of others. The emperor's goal is to preserve and foster existing values, and to re-establish with care those lost, and to acquire by wisdom and righteous means and enterprise those which are missing. The task of emperor is to do good, for which he is called a benefactor. When he stops doing good, then, according to the opinion of the ancient, it is considered that he has perverted the Tsar's mission. The Tsar must distinguish himself in orthodoxy and in piousness, and he renowned in his favor before God. Articles of Dušan's law code, which restrict the prerogatives of the Tsar as a supreme organ of power and put the law above emperor, are 171, 172, and 105, which is connected with them. Although the provisions of these articles are relevant for the judiciary, they are, from constitutional legal aspect, of great importance. Article 105, promulgated 1349 in the first part of the code, is: on the contradiction of charters, imperial charters, which are produced before the judges in any matter which my code contradicts and which the court find invalid, shall be brought and submitted to me. In Article 105, where Tsar's writs clash with the law, the judges have instruction to refer the matter back to him. But experience showed that this procedure was unsatisfactory, and in 1354, Tsar amended it in Article 171, where he issues direct orders to the judges that the code itself is final and authoritative and overrides any separate deeds or enactments issued separately by the Tsar. On the law, a further edict of my Majesty. If I, the Tsar, write a writ, either from anger or from love or by grace for someone, and that writ transgresses the code, and be not according to right and the law as written in the code, the judges shall not obey that writ, but shall adjudge according to justice. Article 172, as a type of guarantee of judiciary independence, was based on the Byzantine tradition, princeps legibus alligatus. Every judge shall judge according to the code, justly as written in the code, and shall not judge by fear of me, the Tsar. How those articles came into the code, into the law code of Stefan Dušan? Were they the result of the independent development of Serbian medieval law, or were they taken from somewhere else? The majority of the researchers of the code of Stefan Dušan from 19th century were firmly convinced that the articles 171 and 172 were independent. However, according to the researches of Serbian scholar Nikola Radojčić, most probably they were taken directly from the Basilica, Greek ta Vasilika, the Imperial Laws, an extensive collection of Byzantine laws began under Emperor Basil I and completed in the first year of the reign of Leo VI. In my paper, you can find the original Greek text from the Basilica. However, Croatian scholar Marko Kostrenčić draws attention to some provision of the Bulla Aurea of Andrea II, in which the similarities with Articles 171 and 172 could be found. This is the Article 30 of Bulla Aurea, quoted also in my paper. Besides Articles 171 and 172, the Code insists in many of its provisions that duties are executed in accordance to the law and that nothing is done against the law. Because of the lack of time, I cannot present all of them, but they are of three types. First, articles regulating the relations between social classes. Second, provisions about judiciary. And third, provisions in the administrative area. Thank you very much for your attention, and one more time, great thank you for organizer who invited me to participate in this very, very important meeting. Thank you.